So yesterday, the SEC issued a no-action letter regarding custody of crypto assets. Let's talk about it. So as I mentioned in a previous video, with the SEC, when they issue a no-action letter, it's different than the CFTC because the CFTC no-action letters apply only to the person requesting it. So another person could not rely on a CFTC no-action letter even if the facts were the same. However, with the SEC, once they issue a letter, anyone who has the same facts as in the letter can rely on it. So if you were engaged in the same type of activity in this letter, Simpson, Thacher, and Bartlett, which is a law firm, you would just follow the no action letter. And if anything got you in trouble, you would whip this out. And if your facts are the same, you would be fine. But again, with the CFTC, everybody needs their own no action letter. So what happened here? Well, when you give your money to a mutual fund or an investment advisor, they would have to keep it with somebody who is approved by the regulator. So under the CFTC's rules, for instance, if your money is with an FCM, which is the equivalent of a broker-dealer on the commodity side, there are certain entities that they can keep it with. And once it's with those entities, only certain things that they can invest the funds in for safekeeping. And it's the same on the security side. So under the previous chairman with Gary Gensler, he made his dislike of crypto well known, and he made it very difficult for funds to invest in crypto and be compliant with the SEC's rules. The current chairman is more favorable to crypto. However, the way the SEC's rules are drafted might prevent a problem. It might present a problem for some funds because of how they custody their customer assets. So as explained in the letter, the funds have to keep their securities and investments with certain custodians, usually banks. And the problem comes in because bank is defined to include a banking institution or trust company which does traditional banking activities like taking deposits and which are under the authority of the controller of currency and which is supervised by a state or federal authority having supervision over banks, and that would include the FDIC. And the problem is that some of these companies that have sprung up and are used commonly to store crypto securely wouldn't meet this definition because a lot of them are state trust companies, not actual banks. And what's the difference? Well, a state chartered trust company is an unusual animal. As I said, it's not subject to FDIC regulations, and they don't make commercial loans and don't take deposits, and they're not affiliated with a bank, and generally are only allowed to do business in the state in which they're chartered and are supervised by that state. There are a couple of wrinkles there. So some states have reciprocity with other states, and if this state chartered trust company is in a state that has reciprocity with your state, and they open up an office in another state which has reciprocity, it can get complicated, but that's the basics. They are not supervised by a federal regulator. They don't have FDIC insurance, and they generally only operate in the state in which they're located, but some of them have taken to becoming custodians for crypto assets, and they don't fit within that definition of acceptable custodians. And so these funds that want to trade crypto with retail customers and operate as mutual funds, they need this no action letter in order to keep using these companies which have experience custodying these assets. And this no action letter will allow you to do that with a state trust company, again, that doesn't have FDIC insurance and is not regulated by the federal government. As long as you perform your due diligence and you are satisfied that they are authorized by the state banking authority to do what they're doing, and that they have internal policies and controls in place to safeguard the crypto assets, and that the fund that's depositing money with them reviews their annual financial statements of the state trust companies, as well as the internal control report were prepared by the accountants. And if you want to see the actual definitions and sections that they cite, you can find them on this website, Cornell's Law website, or if you have a copy of the federal regulations, which I do here, you can just look them up on paper like a dinosaur. But the important things to remember, if you are a state trust company, you can accept these assets. And if you are a mutual fund, a fund under the Investment Companies Act of 1940 or Investment Advisors Act, you can deposit customer money with these entities as long as you've performed your due diligence and you're satisfied that they meet the requirements for this no action letter. And you can rely on this specific no action letter because, as we've said with the SEC, you can rely on somebody else's no action letter. But with the CFTC, everyone would need their own no action letter, even if the facts are the same. And I will put a link to this in the comments so you can look at it yourself if you like. If you read SEC letters and CFTC no action letters, the SEC does something here that I've never seen anyone other than British attorneys do. The SEC uses the phrase "for the avoidance of doubt." It's not the first time I've seen it at the SEC, and I'm sure it won't be the last. And it's something I've never seen anyone besides British lawyers and people at the SEC use. One, because it's the use of the passive voice, which you shouldn't do in drafting. You should use active voice to make it clearer. Two, it's completely unnecessary. You could just delete that and say all requirements of the custody provisions shall apply. Or instead of saying "for the avoidance of doubt," you could just replace it with "to be clear." But anyway, other than that, great job, Taylor. If you have any questions or comments, leave them below. Or if you have another video that you'd like to see on a topic of interest to you, leave it below and I'll see what I can do. Have a great day, everyone.